Do you know what the law says now? Your husband, after you divorce with him, he cannot maintain you. That is the decision of the Court of Appeal. Can you imagine? The Court of Appeal has said a divorced woman cannot be maintained by the husband who has divorced her. The courts have said men have carried women for long. Sasa punda amechoka, punda lazima azushwe mizigo. The judges of the Court of Appeal wamezusha wanaume mzigo. Today we are dealing with during the divorce. Can a wife be maintained? Is it your responsibility to maintain your wife? Under the Muslim law, that is a law different. We shall be looking at the Muslim law that deals with maintenance of wives. We are looking at 4 types of marriages. African Christian marriage. Those are marriages that are conducted in church. Then we are also looking at marriages conducted at the Attorney General's office called Kwadisiapo. Then we are also looking at African traditional marriages and Hindu marriages. Can you maintain your wife? Under the old law, it was mandatory, and that is why the law was providing for alimony. And in alimony, you could maintain your wife. That law has changed. My ladies, that law has changed. From Court Helicopter, this is a wake-up call. We are not scared to be criticized. We are not scared to be abused, so long as we bring you what the law says. Do you know what the law says now? Your husband, after you divorce with him, he cannot maintain you. Too bad. It's not me. It's not Bramwell who you blame for getting us this authority. It's not us. That is the decision of the Court of Appeal. Can you imagine? The Court of Appeal has said a divorced woman cannot be maintained by the husband who has divorced her. Let us look at the facts of this controversial decision. This is a Court of Appeal at Mombasa. Justice Mahandia, Justice William Ouko, and Justice Minoti, all of them the judges of the Court of Appeal, sitting in Civil Appeal number 45 of 2016 between NBR versus JO. This was a decision that was challenged to the Court of Appeal from a high court sitting in Mombasa, where Justice J. Odero J. gave a judgment dated 18th December 2014. What is the issue in this matter? You'll be shocked. The issue in this matter is that the person was married under the Marriage Act on 7th June 2012 in Mombasa. They divorced in divorce cause number 25 of 2014. On 2014, they filed for a matrimonial causes. On the same day, the respondent applied under the repealed Matrimonial Causes Act for alimony pendente of Kenya shillings 1 million per month. She wanted to be maintained 1 million shillings per month. She said that the appellant had evicted her from the matrimonial home that she was living with and maintaining the child of the marriage. That while living with the child, with the husband, she was used to a standard of life of between Kenya shillings 600,000 to 1 million shillings per month. So she said when they were husband and wife, her lifestyle per month was between 600 to 1 million shillings. She used to be given by the husband. And therefore, the case was a very serious issue. Can the court maintain this amount of money. The High Court was not satisfied with giving 1 million. Instead, the High Court gave her 100,000 shillings per month. This is the High Court. She complained that the judge in the High Court only gave her 100,000 shillings per month. She appealed, heading to the Court of Appeal, asking for 1 million shillings. She says she also contended that the 6 million shillings that the appellant had deposited for the benefit of the child was not available. So she wants 1 million shillings per month. What did the judge say? The judges quoted the celebrated case of WMM and BML where the court said, in light of Article 45(3), the criterion in determining the rights and obligations of spouses in a marriage must treat the husband and the wife as equals, and neither has a greater or lesser obligation than the other in relation to maintenance. The judge is saying Article 45(3) must be looked at. He says, in short, in cases where, as here, spouses have no children, a wife does not enjoy advantage over her husband, or the vice versa, and the age-old tradition in which men were deemed to be the sole breadwinners and to carry the burden of maintaining their spouses does not hold true anymore. Under the Constitution, that is Article 45 and Article 27, the respondent has a duty to support and maintain herself. No less than the petitioner has to support himself, and there is no greater obligation on the part of the petitioner to support himself than there is on the part of the respondent to support herself. The judge is saying, all of you, support yourself. Wewe mwanamke, support yourself. Finance your life. Wewe mwanaume, finance your life. There is no responsibility for a man to support, to finance the life of a former wife. The judge goes on to say, no spouse who is capable of earning should be allowed to shirk his or her responsibility to support himself or herself, or turn the other spouse into a beast of burden. Oh my God. Let me read. Bramwell got this one. This is a killer punch. No spouse who is capable of earning should be allowed to shirk his or her responsibility to support himself or herself, or turn the other spouse into a beast of burden. What does that mean? If a woman has gone to school, let us be honest, you have a degree, you have a diploma college, you have a Form 4 certificate, you have the capacity to work, you have hands, you have the brain. Why can't you work? This is the judge asking. You cannot turn, you cannot refuse to work and turn your former husband into a beast of burden. Do you know the beast of burden? Ni ile punda. Imebeba mizigo. Punda imechoka. Punda lazima iweke mzigo chini. The courts have said men have carried women for long. Sasa punda amechoka. Punda lazima azushwe mizigo. The judges of the Court of Appeal wamezusha wanaume mzigo wa kubeba baada ya divorce. This is how the judges proceeded. The judges went ahead and said the constitutional provision, Article Article 45(3) emphasizes the equality between spouses. No one spouse has a right to be maintained by another simply by virtue of his or her gender. You cannot be maintained because of your gender. The question that immediately comes to mind is what efforts, if any, is the respondent making to provide for her own keep? She is an able-bodied woman and is perfectly capable of seeking some form of sustenance for herself. The purpose of maintenance is not to financially punish or cripple one party at the expense of the other. The purpose of maintenance is not to financially punish or cripple one party at the expense of the other. Nor is its purpose to make one spouse a human ATM. Oh, my friend, you can't make a husband a human ATM machine. These judges, were they cruel to women? Are these judges really? The judges are saying men have been turned into human ATMs. You walk to Equity Bank, there's an ATM. You walk to Barclays Bank, there's an ATM. You walk to KCB, there's an ATM. You walk to Family Bank, there's an ATM. All the banks have ATMs that women have been extracting money from the ATM, called men. I don't agree with this, but this is the position of the Court of Appeal. The judges now finalize and say no spouse who is capable of earning a living ought to be allowed to shirk his or her responsibility to do that. If you are able to earn, my friend, you are done. But the judges are very clear. If you married for men, if you married a woman who never went to school, if you married a woman who never went to school, you will have to continue maintaining that woman. But if the woman went to school and has a job, has a qualification, you women, woe unto you, the judges. We come to the conclusion that this appeal has considerable merit. We allow the same and set aside the order for payment of alimony, pendelete of Kenya shillings 100,000 per month. So the judges removed the 100,000 my good lady had been given by the High Court. If she was properly advised, she could have run away with the 100,000 shillings she was given at the High Court. But she was more vicious. She wanted more money. She was not satisfied with the 100,000 the judge gave her at the High Court. She wanted 1 million shillings. She went to the Court of Appeal. She lost. Mtaka jote hukosa vyote. That is the final. Bramwell got me that msemo from Tanga when he went there, akaniambia mtaka chote hukosa vyote. Tamaa iliua fisi. Tamaa iliua fisi. Our lady was given 100,000. She wanted 1 million shillings. The judges, Justice Asike Mahandia, Justice William Ouko, Justice K. Minoti, judges of the Court of Appeal, sitting on the 10th day of March 27, gave a fatal blow. She lost everything. What are the lessons in this episode? Is one, for men who married women who have no educational capacity to be employed, to be engaged in any work, you will maintain your wives after divorce. For the women who are able to work, you cannot get anything after divorce called alimony. Go to the division of matrimonial property. That's where you'll be supported with. It is a bad day for the ladies. We apologize that we are bringing you the earth-moving decision of the Court of Appeal that now settles that matter, that you cannot get anything if you have capacity to work. My advice to my good sisters, my good daughters, my good aunties, my good mothers is work hard. Article 27 provides for equality. Everybody is equal before the law. It removes the gender-based argument that I'm a wife, I'm a woman. The Employment Act provides for equality of salary. No woman is paid a lesser salary because she's a lady. Employment is based on merit. Wakili Dan Sanomari, thank you very much.